Exit the vehicle now. The command cut through morning traffic like a gunshot. Blue and red strobes painted the inside of a black Mercedes in fractured staccato. On the dashcam, the recording light glowed steady red. 09-12-14. 5 blocks from the federal courthouse, where the judge assigned to the criminal calendar would normally be stepping into a packed courtroom, a uniformed officer was advancing toward a driver whose hands rested on the wheel, calm and deliberate. Judge Elaine Washington had been awake since dawn. A former military intelligence officer and a jurist appointed to the federal bench years earlier, she wore restraint as a habit. Measured breathing, eyes that catalog details before reacting, the voice of someone trained to negotiate under pressure. On this morning, she wore a dark coat over an ankle-length dress. A thin leather folder rested on the passenger seat. Her federal judicial identification hung inside her purse. The courthouse was 3 traffic lights away. On the sidewalk, a man lifted his phone and began to record. Another hand joined the first. An assistant who had once worked for the judge, Thomas Chen, had seen the cruiser pull in behind the Mercedes and recognized the silhouette. He stepped closer and tapped his own time-stamped video, 09-12-35. Officer Brentwood had the posture of certainty. He had been on the job long enough to assume the weight of the badge entitled him to a quick script. A hunch, a stop, a quick resolution. When the Mercedes matched the description of a recently reported stolen vehicle in a general rundown the dispatcher had alerted about 30 minutes earlier, Brentwood meant to act fast. He approached, voice raised. "License and registration. Step out of the vehicle." Elaine Washington reached over, unclipped her seatbelt slowly, and produced a small rectangular card marked with the seal of the federal judiciary. "I'm Judge Elaine Washington, U.S. District Court," she said. Her tone was flat, without plea. Officers are taught to present themselves clearly. Judges learn to be precise. Brentwood's eyes slid from the ID to the driver and back. He radioed softly into his shoulder microphone. On dashboard video, the red light kept its silent blink. 09-12-58. A few seconds stretched like an elastic band. Officer Reynolds, the junior partner in the cruiser, hovered near the open passenger window. He had been a patrol officer less than 2 years, still learning the choreography of stops. Who kept the car clear, who watched the hands, who kept watch for weapons. His shoulders were tight. On the dashcam, his face, framed by the cruiser's headrest, flickered with doubt. "Dispatch 312. I have the vehicle stopped. Confirm plate check." Brentwood's voice was clipped. The dispatcher replied in monotone. In the recording, dispatcher's words were brief. "Run on plate, hold." Exhibit 3 will later display the verbatim dispatch transcript. But the dashcam captured more than the exchange. It captured Brentwood's impatience. It captured the moment he reached through the open window and, without a second officer taking control of the driver's hands or issuing a clear order consistent with department policy on stops involving suspected stolen vehicles, began to instruct Washington out of the car. She complied without resist, intentional, composed. That was when Brentwood moved to handcuff her. The metal closed with a small, distinct click. 09-13-22. A bystander's phone zoomed in on the close-up. The judge's ID visible, the gavel seal, the calm professionalism of a woman whose job was to uphold rights and process. Thomas Chen kept his phone steady, breath visible in the cold air. His video would later be Exhibit 2. Bystander footage, 09-12-35 to 09-14-10. It ranked, in raw evidentiary terms, with the dashcam, but carried the witness's angle, the public record of a public official being restrained. Officer Reynolds reached for the registration that was inside the glove compartment. He found, instead, folded judicial robes in the trunk, a robe bag peeking between an umbrella and a briefcase. He called that detail almost under his breath to Brentwood. "She's got robes in the trunk, judicial robes." Brentwood responded with a short exhalation. He glanced at the ID and then back at his partner. His eyes hardened. "We're detaining her," he said. The handcuffs tightened. The tape from the cruiser showed the judge's hands momentarily limp at her sides. The wrists bowed with the metal unbending them into a restraining shape. Any seasoned observer could mark the protocol that had been missed. A vehicular stop for a suspected stolen car usually requires confirmation from dispatch and a measured approach, particularly when the stop grows into an arrest. Reasonable suspicion, the legal standard that allows an officer to briefly detain someone on the street, must be founded on articulable facts, not a hunch. Probable cause, the higher bar necessary for arrest, requires evidence that a crime has been committed. In the hum of flashing lights, those legal lines blurred. A civilian voice on Chen's video chorus, "She's a judge." Brentwood clipped the radio again and called for backup. The cruiser's red light at the top of the dashboard continued to blink. 0913:35. Two things happened almost at once. First, other phones in the area began to point toward the scene. Citizens who previously would have been passive bystanders found themselves activated by the sight of public force in action. Second, Lieutenant Diane Foster received the radio call for backup as she left a nearby precinct meeting. Foster had spent 20 years in the department. She was a lieutenant schooled in procedure, unimpressed by bravado, and keenly aware that a uniform can never be a permit to overlook a process. She pulled up on the scene within minutes. When Foster arrived, she observed a tableau that made her mouth set. The Mercedes sat curbside, lights strobing across a polished hood. Brentwood stood at the window, words exchanged in low intensity. Reynolds lingered, face flushed. Foster took in the facts in quick succession. The judge's ID clearly displayed, the handcuffs, the presence of several civilian courtings, the trunk with robes visible, and dispatch chatter that, she later noted in her report, should have tempered any immediacy to arrest. Foster's arrival changed the tenor of the stop. She moved with authority that was not theatrical but procedural. She requested to see the driver's identification, looked at it, and then turned to Brentwood. "Lieutenant Foster, Metropolitan Police," she said, but the formality in her voice did not mask a command. "Remove the restraints. We'll take the vehicle and driver to the station for documentation." Brentwood hesitated. This hesitation would be later described in internal interviews as the inflection point. The officer who had initiated the detention narrowing his focus on justification rather than correction. Reynolds, standing behind him, inhaled and looked down. On dashcam, Foster's hands, steady, precise, guided Brentwood through the steps. "You should have verified with dispatch before detaining," she said. "We tape everything now. Take the car to the station." She ordered the restraint removed at 09:14:58. The cuffs came off. The instant the metal dropped away, the air shifted from confrontation to a new, more controlled set of priorities: evidence preservation, documentation, and internal notification. Washington, hands-free, did not storm away or lash out. She shifted into a strategic mode that would later define much of the case: speak clearly, preserve the record, and let the facts do the work. As the officers ready to transport the van and its occupant to the precinct, Washington reached quietly for her phone. She called her clerk, Thomas Chen, and asked him to stay put and forward his video to her assistant. "Preserve it," she said, a simple administrative instruction that would carry outsized weight in the days ahead. Then, also quietly, she said, "I want every recording preserved: dashcam, bodycam, street cams, and any surveillance from nearby." Foster ordered an immediate preservation of the dashcam footage and the bystander recordings. In police practice, that order is a small procedural command that, when followed, begins the chain of custody that prevents evidence from disappearing or being altered. The command moved the incident from a local street occurrence into a documented, auditable event. At the precinct, the intake room smelled of coffee and fluorescent light. Cameras on the wall recorded every footstep. The watch commander signed off on an expedited evidence hold. The dashcam cartridge labeled and sealed, time-stamped at arrival 0929. Witness statements were taken. Thomas Chen completed a sworn statement of the events, and his phone's metadata confirmed the timestamp of the original video. Officer Reynolds gave a preliminary interview at 9:42, less than half an hour after the stop. His voice was quieter than it had been on the street. He described the sequence of events in halting sentences, and his answers betrayed a kind of retrospective clarity. "I think I could have asked more questions," he said. "I saw the robe in the trunk and I told him. I didn't stop him." Brentwood, meanwhile, was moved into a room where a sergeant took a formal statement. He repeated his belief that the car matched the description sent out by dispatch. He insisted he had acted within the discretion officers exercise in the field. He documented the plate run he had ordered and noted in his report that dispatch information was at times inconsistent depending on caller descriptions. But that report would be read against recorded facts. The precinct's evidence room held more than one source of truth. The dashcam showed dispatch clearing the plate before the officer ordered the handcuffing. Exhibit 1, dashcam camera, 9:12:14 to 9:15:03, captured the precise timing: the cruiser approach, the stop, the exchange of words, and the faint dispatcher chatter. Exhibit 2, bystander video, 9:12:35 to 9:14:10, provided the public angle. Exhibit 3, dispatch transcript, 9:11 to 9:16, recorded the communications that would later be compared line by line. Inside the watch commander's office, a small group gathered around a monitor. Lieutenant Foster pulled a thumb drive from her folder and plugged it into the system. The dashcam hummed to life. The staff lawyer from the department remained silent, watching the frame-by-frame playback. Foster paused at a moment where dispatch indicated a negative on the stolen vehicle flag for the plate that Brentwood had stopped. The room was quiet enough to hear the fluorescent buzz. "Here," Foster said, pointing. "Dispatch confirms there's no stolen vehicle report for this plate at 9:12:01. The watch commander raised an eyebrow. "Then why did he detain her?" Foster finished. Her question hung open, but was already changing the trajectory of the event into an internal review. In practical terms, it was the moment the department acknowledged that an action taken by an officer might not align with the evidence on record. The precinct's legal advisor called the chief's office. By 10:05, the chief was notified. An administrative email thread began to populate with attachments: dashcam exports, videos, and preliminary witness statements. Among those was a notation from Thomas Chen, appended to his witness statement. "I could see her badge. She wasn't resisting. She was dignified and asked for the recordings to be preserved." Back in the room, Foster moved to secure additional surveillance: a city-owned traffic camera at the corner, security footage from a nearby coffee shop, and the courthouse's own external cameras. The courthouse footage captured the judge's approach earlier that morning at 09:07 and later at 09:16 as her vehicle was moved toward the patrol wagon. That footage would later be Exhibit 4, courthouse exterior camera, 09:07 to 09:17, confirming her route and the time of movement between public spaces. There are moments in law and policing when visible evidence functions like an accelerant. The combination of recorded dashcam and civilian videos, coupled with dispatch logs that appeared contradictory to the officer's account, made this one of those moments. The law allows for discretion, but it also requires accountability. When cameras and records show a divergence between a subjective belief and an objective timeline, the institution must reconcile the two. Elsewhere that morning, Chief Martinez sat in his office holding a phone to his ear for an extended period. He was told there had been an incident involving an on-duty officer and a federal judge. He was told that the dashcam and bystander footage were being forwarded. He was told that the lieutenant at the scene had ordered the restraints removed and that the judge had been transported to the precinct for documentation. For Martinez, the political calculus was immediate and real. A public official detained in handcuffs 2 blocks from a courthouse would not stay merely a local personnel matter. The chief made a note to involve the department's internal affairs and to notify the city attorney.
He also instructed his staff to prepare an internal review team, an accountability task force that could handle high-profile incidents with rapidity. His instincts were to move fast, not to preempt findings, but to ensure that the institution did not appear to shirk responsibility. The story at this point began branching into several parallel vectors. One was the personal, how the judge felt in those early minutes after release, how she balanced anger and strategic restraint, and how she chose to use the procedural tools at her disposal rather than public spectacle. Another vector was institutional, who in the department would protect procedures and who would resist scrutiny, how evidence would be presented, and whether patterns in an officer's record would emerge under a renewed focus. A third vector was public, the bystanders who recorded the event, whose footage would hold the department publicly accountable in a way internal reviews rarely do. In the intake room, Washington sat in a metal chair, a cup of coffee cooling on the Formica table. She spoke softly with Assistant U.S. Attorney Thomas Chen and with Lieutenant Foster. "Preserve everything," she said again. "There should be no question about this record." Foster nodded.
She filed the chain of custody forms, initialed every box, and asked the evidence technician to log the dashcam and bystander media as restricted access until the watch commander's review was complete. Those actions, small, bureaucratic, precise, formed the institutional scaffolding that would make the moment impossible to erase. Officer Reynolds made a call on his own phone later that morning. He asked to speak privately with an internal affairs investigator. In his initial comment, he said that he had been uncertain, that he regretted not intervening quickly enough, and that he wanted to correct the record. His cooperation would later be framed as a turning point in the internal case, a junior officer choosing procedure over loyalty. Brentwood sat in a different room and prepared his written report. He described the stop as he had perceived it and cited the dispatcher's original bulletin as justification. He wrote that he had reasonable suspicion to detain the vehicle pending verification. The problem, as the dashcam and the dispatch transcript later showed, was timing. The audio established that dispatch had clarified the status of the plate before the handcuffs went on. Under departmental policy, when questions arise about the timing and justification of a detention, the matter moves beyond local review into an administrative investigation. That process looks for deviations from policy, lapses in judgment, and any patterns in past complaints. It also solicits statements from supervisors and considers whether training or supervision was lacking. In this case, the initial facts were forming into a potentially pattern-based concern because a search of Brentwood's personnel file, pulled later that day, showed a string of prior citizen complaints mentioning unnecessary escalation during stops. Those complaints were largely unresolved, filed away as no sustained finding or insufficient evidence. The presence of earbuds in those files neither proved wrongdoing nor exculpated Brentwood, but it did mark a pattern that investigators would be compelled to examine. By 10:43, the first tranche of formal documentation was in. Dispatch logs had been exported, dashcam and bystander footage were copied to multiple storage devices, statements from witnesses and officers were recorded. The evidence was beginning to form a mosaic. Washington, meanwhile, requested to be kept apprised in writing. She did not demand headlines. She asked for the formal preservation of the record and for immediate notification of any administrative steps taken by the department. This decision to insist on formal channels instead of public outrage would later be read as strategic, an insistence that a legal process, once armed with incontrovertible evidence, could compel the institution to act in a way public anger often could not. At the center of the precinct's processing room, a small whiteboard listed the next actions: preserve dashcam, collect courthouse cam, interview Reynolds at 0942, Brentwood at 0955, notify Chief Martinez, log into IA. A chain of custody form recorded the dashcam as Exhibit 1, dashboard camera 0912-14-091503. Thomas Chen's phone video was entered as Exhibit 2, bystander footage 091235-091410. The dispatcher's exported transcript was marked as Exhibit 3, Dispatch transcript 091-09209. The entries were methodical. Their existence transformed a private, contested moment into prosecutable material. The precinct lawyers and the chief's office began to assess risk. An internal memo, drafted at 11:12, advised that the circumstances likely warranted an immediate administrative suspension for Brentwood pending investigation to preserve public confidence. It recommended that the personnel file be pulled and assessed for patterns of prior complaints. It advised early coordination with the city attorney's office for any civil litigation risk, and suggested caution in public statements. But the department knew something else. In an era of ubiquitous recording, what the public sees becomes a primary text. When several independent sources show a sequence of events that differs from an officer's narrative, the department's credibility erodes. Choices made in those first 90 minutes determine whether the institution will be seen as accountable or evasive. At 11:28, Chief Martinez walked into the watch commander's office. He looked at the playback, nodded once, and set his jaw. He tapped his finger on the desk and then dialed the number for his legal counsel. The first practical consequence of his call was not a headline, but an administrative directive. Preserve everything, start an immediate administrative review, and consider removing the officer from street duty pending further investigation. In the department's internal script, that second step, an immediate administrative suspension pending investigation, is how an institution signals that it is taking the record seriously. Across town, news of the stop was already trickling into social feeds. Videos, uploaded by witnesses, began to loop in feeds and group chats. The pattern now shifted again. Local attention amplified the institutional imperative to respond transparently. Washington's early insistence on evidence preservation meant the department could not easily displace the narrative. The objective record existed and had been archived. There was a human calculus in all of this. Officer Brentwood's mistake, whether rooted in poor judgment, faulty training, or institutional blind spots, had become visible in a way that previous incidents had not. In the precinct, analysts began to pull Brentwood's personnel history, commendations, complaints, training completion records, prior supervisory notes. A troubling rhythm appeared. Several prior stops where escalation was reported and where the officer continued detentions despite dispatch confirmations. At least 2 prior complaints mentioned similar behavior, each rising to the level of disputed and never fully sustained due to lack of recorded evidence. Here, however, the record existed. The moment moved from local procedure into public accountability. When Lieutenant Foster authorized the restraint removal and the transport to precinct, she had not only de-escalated a single incident, she had, in effect, created a controlled environment where evidence could be collected under supervision. That choice, a professional correction, would ripple outward. By late morning, the city's Internal Affairs Division had opened a preliminary inquiry. The watch commander had recommended an expedited internal review. The chief had floated the possibility of placing the officer on administrative leave pending investigation. These were immediate, visible forms of accountability, actions an institution takes to show that a misstep will not be ignored. Yet in the watch commander's office, the mood was not celebratory. The presence of evidence did not guarantee a legal or disciplinary conclusion. It did not guarantee conviction, termination, or systemic overhaul. It did, however, permit the process to begin in earnest. Evidence was an invitation to inquiry, and inquiry could lead to consequence. Washington took a step that morning that would later be cited as pivotal in shaping the course of the case. She declined to make the incident a public spectacle. Instead, she insisted on formal channels. She filed a written complaint, requested immediate preservation orders, and called for an independent review. Her approach blended the personal indignity of the stop with a professional understanding that the law moves not on passion but on record. By noon, the precinct had assembled a preliminary packet for the departmental lawyers and the city attorney's office. The packet included the original dashcam export, Exhibit 1, Thomas Chen's bystander video with attached metadata, Exhibit 2, the dispatcher transcript, Exhibit 3, and the courthouse surveillance footage, Exhibit 4. It also included the initial witness statements and the first tranche of Brentwood's internal write-up. The packet, when opened, would allow investigators to render a preliminary assessment of whether policy had been violated and whether there was sufficient cause for administrative action. Officer Reynolds walked back into the watch commander's office around 12:10. He sat down and exhaled. He had spoken to an internal investigator and given a statement admitting that he had seen the robes in the trunk and had not acted to prevent the handcuffing. "I didn't follow up," he told them. "I should have said more." That sentence, simple and remorseful, would later mark the beginning of Reynolds's arc from hesitant partner to cooperative witness. It would also serve as an internal example of the department culture that necessitated reform, peer pressure, loyalty, and the difficulty of speaking up when senior officers make a call. As the clock turned toward midday, the precinct's legal team convened a short, focused meeting. They discussed options: expedited administrative suspension pending investigation, coordination with the U.S. Attorney's Office because the affected party was a federal judge, and the preservation of material for potential civil discovery. The legal counsel emphasized that any public statement should be narrowly tailored to the facts, preserve the record, avoid speculation, and acknowledge the existence of an internal review. Before the meeting dispersed, Lieutenant Foster signed an order directing that all cameras in the vicinity be archived and that the original dashcam file be written to an immutable forensic image and duplicated to separate secure drives. She circled the date and time on the form, 0912-0916. The precision of that notation would later become central in comparing Brentwood's timeline to dispatch. Outside the precinct, a small crowd began to gather as postings of the bystander videos had already spread. People debated in real time. Some expressed shock that a judge could be detained like any civilian. Others focused on the officer's responsibility to act on reports of stolen property. The nuance was lost in the immediacy. The nuance was exactly what the evidence preservation procedures were meant to protect. And yet, even as evidence mounted and the department moved to secure its record, the human story remained complex. Judge Washington walked out of the precinct later that afternoon with a small statement, concise, dignified, and focused on the facts. She expressed gratitude that evidence would be preserved and that the department would conduct an internal review. She did not call for vengeance, she called for process. In the watch commander's office, the packet was assembled and delivered to the internal affairs investigator. The investigator glanced at the exhibits and then, after a moment, looked up as if to measure the gravity of what the evidence implied. Chain of custody forms were filed. Requests for Brentwood's phone records and personnel file were drafted. Phone records are not conclusive on motive, but they can be revealing about associations. A preliminary request noted some traffic in Brentwood's contacts with a former officer who had been the subject of a separate departmental inquiry months earlier. That connection, cataloged for follow-up, would later appear as a potential thread in a pattern analysis. At this point, however, it remained a lead, not a finding. By late afternoon, the department's legal team recommended that the chief place Brentwood on administrative leave pending further investigation. The chief approved the recommendation. The immediate administrative action met one of the title's promises. An officer's mistake produced rapid, concrete personnel consequences, suspension pending investigation. But the story was not finished. The packet of evidence, preserved and labeled, had become more than the sum of its parts. It was the basis upon which a public official and an institution could demand accountability, and it would soon be the foundation for a much larger review. Tonight, the dash cam would be reviewed again, the telephone logs would be pulled, and the personnel file would be scrutinized. The morning scene, lights, the click of handcuffs, the blink of a recording light, had already begun to ripple outward into a legal and institutional reckoning that would test the department's capacity for honest self-assessment. When the precinct lights dimmed and the day's immediate bustle subsided, an evidence locker clerk placed the duplicate drives in 2 separate safes and stamped the chain of custody forms with exact times. The precision was ritual, an administrative faith that, one day, may decide the fate of careers and reform. It was also the mechanism through which a single recorded mistake could be turned into a public, verifiable account, one that, in turn, could produce immediate administrative consequences. Outside, the city streetlights came on. Somewhere in a neighborhood feed, Thomas Chen's upload had already reached thousands. The public would soon know more than the precinct could control. The department's response now had to be not only procedurally correct, but visibly so. In the quiet of her chambers that evening, Judge Elaine Washington opened a file folder. Inside lay the day's chain of custody notices, the list of exhibits, and a brief memo she drafted requesting a full review and preservation order to be filed in the appropriate court. She wrote in plain language that would make its way into the formal record. Preserve all media. No deletion. Provide immediate copies to her counsel upon request. She signed the memo, the ink dark and deliberate. The gears of institutional response had engaged. Evidence had been collected, procedural steps had been taken, and an officer who had acted on a mistaken impression had been removed from active duty pending review. The legal machinery was warming up. The scene that had opened with a flicker of red on a dashcam was now giving rise to an administrative chain that would test policy, training, and accountability long after the lights of that cruiser had stilled. Later that night, an internal email summary went to the chief, to internal affairs, and to the legal counsel. It stated, in measured language, that an incident had occurred involving the detainment of a federal judge, that the dashcam and bystander footage suggested a discrepancy between the officer's actions and the dispatch transcript, and that an administrative leave for the officer was recommended. It closed with a procedural note. Preserve all evidence. Prepare for potential external review. The city's legal and political actors were now in motion. The seed of what could become a systemic inquiry had been planted, held up not by conjecture, but by the slow, difficult labor of documentation. Evidence had the odd habit of simplifying what the human heart complicates. It speaks in timestamps and files and chain of custody forms. In that language, busy with numbers and labels, the truth can be arranged in a sequence that compels accountability. The next morning would bring more interviews, the addition of personnel files to the packet, and requests for phone records that could help explain patterns. But in the hours after the stop, the initial promise of the title, an officer's shocking mistake producing immediate, visible justice in the form of suspension and a preservation order, had been realized in concrete steps. The red light of the dashcam had not only recorded, it had initiated an institutional response that could not be easily undone. There remained, of course, many unanswered questions. Why had Brentwood proceeded despite dispatching information? Whether past complaints established a pattern? And what the departmental review would ultimately recommend? For now, the precinct's evidence room held the artifacts of a public event, all stamped, cataloged, and locked away for scrutiny. The convenience of a recording device had turned a street-level mistake into a procedural imperative. Thomas Chen's video continued to circulate. Officer Reynolds slept that night uneasy, but determined to cooperate fully. Lieutenant Foster prepared her notes for the formal review. Chief Martinez arranged for a briefing with the city attorney. And Judge Washington, who had begun the morning with a train of courtroom appearances and ended it with files of her own, prepared for the work ahead, not for spectacle, but for the slow, exacting process of accountability. The scene that began with a command, a flash of red, and a click of metal had set in motion administrative levers that would reach far beyond a single stop. Evidence had become the axis on which a rapid institutional response turned, not because the public demanded it, but because the protocols were followed and the record refused to be silent.
By noon, the packet sat on a judge's bench folder, a neat stack of digital files and printed exhibits that transformed a street scene into a case file. The next move would not be an opinion or a plea. It would be a procedural demand that the institution could not evade. Preservation, review, and the question of who would answer for the discrepancy between what the record showed and what the officer's report claimed. Judge Elaine Washington did not want spectacle. She wanted law.
She filed an emergency motion that afternoon, short, precise, and formal, to compel preservation, to request an expedited administrative review, and to notify any relevant federal authority that a high-profile detention had occurred under suspicious circumstances. Her filing asked the court to enter a narrow preservation order, to require immediate handover of all department records related to the stop, and to permit an independent review to ensure the chain of custody and integrity of the evidence. The civil clerk stamped the motion at 13:08. At 1400, Chief Justice Rodriguez convened an emergency bench conference in the federal courthouse's small ceremonial courtroom. The bench was filled with the subdued bustle of court staff and a few counsel, city attorneys, the department's legal advisor, and a representative for the U.S. Attorney's Office. The room felt smaller than its marble implied. The morning's footage had already been viewed by many: law enforcement counsel, the chief's advisors, and the judge whose name was on the motion. The question in the room was procedural but consequential. What immediate judicial steps were appropriate given the evidence? Rodriguez listened to two short presentations. The city attorney explained the department's internal steps: evidence preservation, the watch commander's report, and the chief's approval for administrative leave. The U.S. Attorney's representative outlined the federal interest. A federal judge had been detained. Potential civil rights implications could warrant an independent inquiry. Legal counsel for the police emphasized that administrative and criminal processes remained distinct and asked the court to avoid overreach. Rodriguez, deliberate and precise, asked only the questions necessary to an emergency decision. Were the records secured? Could the court ensure an independent custodian for the evidence? Was there a risk of spoliation? The answer, in the facts already assembled, was no. The dashcam had been forensically imaged. Duplicates were locked in separate safes. Bystander video matched timestamps. Dispatch logs had been exported. The courthouse cameras corroborated movement. Objectively, the record existed. Subjectively, differences remained between Brentwood's report and the recordings. That mismatch, Rodriguez determined, implicated an institutional need for external assurance. He signed an interim preservation order and, in language that balanced deference with urgency, invited the U.S. Attorney's Office to open a preliminary inquiry into whether a pattern or practice of constitutional violations might exist. He ordered the department to provide a complete personnel file for Brentwood and to identify any prior similarly characterized complaints for immediate review. The courtroom's air hummed with the low frequency of consequence. Rodriguez also issued an administrative directive to the chief: an immediate documented suspension of Brentwood pending finalization of the administrative review. That order reflected departmental practice already taken, but the judicial imprimatur made it unmistakable and public. The timing matched the title's promise. The officer's mistake had produced immediate, visible consequences: preservation and suspension, backed now by judicial authority. Exhibit footage presentation began informally that afternoon as counsel walked the judge through the packet. The exhibits were labeled in sequence and narrated with an eye for forensic detail. Exhibit 1, Dashboard Camera, 0912-14 to 0915-03. The clip played without editing. The cruiser's approach, the red recording light, the exchange of words, the radio transmission, everything unfolded in real time. The dashcam's audio contained the interplay between officer and dispatcher, and at 0912-01, a dispatcher voice could be heard indicating a negative on the stolen vehicle flag for that plate. At 0913-22, the handcuffs clicked shut. Exhibit 2, Bystander Footage, Thomas Chen, 0912-35 to 0914-10.
The frame was steadier, the angle lower and public-facing. Chen's video captured the judge's ID in close-up, the robe bag in the trunk, and bystanders' reactions as the handcuffs closed. Exhibit 3, Dispatch Transcript, 0911 to 0916. The export showed time-stamped entries and agent notes. The transcript included the call originating about an unrelated block and a subsequent clarification that the plate did not match the stolen vehicle report at the time Brentwood detained the driver. At 09:13:22, the handcuffs clicked shut. Exhibit 3, Dispatch Transcript, 0911 to 0916. The export showed time-stamped entries and agent notes. The transcript included the call originating about an unrelated block and a subsequent clarification that the plate did not match the stolen vehicle report at the time Brentwood detained the driver. Exhibit 4, Courthouse Exterior Camera, 0907 to 0917. This footage corroborated the timing of the judge's approach and confirmed the public timeline between her arrival and the later transport away from the curb. Exhibit 5, Personnel File Excerpt and Complaint History for Officer Brentwood, 2015 to present. The file documented prior citizen complaints about escalation during traffic stops, mostly resolved without sustained findings due to lack of recorded evidence. It included training reports, performance notes, and a pattern of disputed investigations that later investigation would analyze more deeply for procedural gaps. Exhibit 6, Brentwood phone records, selected dates. The records demonstrated repeated calls between Brentwood and a private contact identified in internal notes as Roger Simmons, a former officer who had been under review in a separate matter months earlier. The frequency and timing of calls on dates proximate to previous stops flagged for review raised questions that an investigator would need to explore. Each exhibit came with narration explaining legal relevance.
The dashcam's timestamp, the counsel said, showed sequence. The dispatch transcript suggested a clearance inconsistent with the timing of the detention. The personnel file suggested a pattern that, when combined with fresh recorded evidence, merited an expanded inquiry. Rodriguez's ruling formalized those connections: immediate preservation, cooperation with a federal preliminary inquiry, and confirmation that the suspension remained in effect. In the days that followed, discovery moved at an unusual clip. The U.S. Attorney's Office opened a preliminary review to determine whether a civil rights inquiry was warranted. The department's Internal Affairs Unit continued its administrative investigation. The two tracks ran parallel but separate, one looking at departmental policy and possible employment consequences, the other at potential criminal liability for false arrest or civil rights violations. Witness interviews that would later populate affidavits and testimony took shape under oath. Officer Reynolds's statement, taken formally at 9:42 and later through a sworn declaration, was direct. He described the trunk and the robes, his knowledge that the plate check had been inconclusive, and his hesitation to confront Brentwood more forcefully on the scene. "I didn't want to contradict a senior officer in the moment," he said in his sworn account, "and I regret that now." Reynolds's cooperation would prove crucial. His contemporaneous admission filled gaps that the recordings could not fully explain about the internal dynamics of the patrol. Lieutenant Diane Foster's formal report emphasized procedure. She described her arrival at 9:14:50, the removal of restraints at 9:14:58, and the order for transport to the precinct for documentation. Foster's testimony stressed that when an officer encounters conflicting information from dispatch and field impressions, the correct procedural path is to verify through dispatch and to de-escalate where feasible. Her report contained a methodical checklist of steps she directed once the judge was identified: removal of restraints, preservation of recordings, securing the trunk as evidence, and immediate notification to command. Foster's choices that morning would later be referenced in training modules as an example of corrective, accountable leadership. Thomas Chen's bystander footage was authenticated through phone metadata and cloud backups. He provided a sworn account of why he recorded. He recognized the judge and was concerned by the escalation. Chen's footage was not only corroborative but decisive. It provided an angle that removed doubt that the dashcam alone might have left, and it allowed civilian testimony to be part of the evidentiary tapestry.
For courts and investigators, such corroborative civilian footage had become, in practice, a crucial check in accountability cases. Brentwood's statement, in contrast, attempted to reconcile a mismatch between perception and recorded time.
He described acting on a dispatch bulletin and on a perceived match to the reported vehicle. When confronted with the time-stamped dispatch log that indicated a negative at 9:12:01, he explained that background noise and multiple radio calls could have created confusion. Under questioning, however, he had difficulty explaining why he had proceeded to handcuff without a clear, contemporaneously articulable justification beyond a training-honed instinct. That difficulty would be central to the disciplinary review, whether his conduct stemmed from poor decision-making, inadequate training, or something more systemic. Investigators then layered the exhibits into an analysis. They examined the personnel file for patterns. They compared Brentwood's stops over a 2-year window, analyzing complaint types and resolutions. Statistical analysis, simple counts and timeline charts, indicated that Brentwood had been the subject of 8 complaints alleging unnecessary escalation. 6 lacked corroborating recorded evidence. That pattern could be explained by the absence of cameras in prior incidents. It did not in itself constitute proof of systemic misconduct. But when a pattern of similar allegations appears, and one stop is now captured on multiple independent recordings, the combined weight compelled a broader look. Phone records added another analytical layer. Calls between Brentwood and Roger Simmons, frequent and clustered around certain dates, were not evidence of wrongdoing by themselves. Phone metadata cannot prove motive. Still, the records warranted inquiry. Were those calls relevant to past dispatch information, to sharing of policing tactics outside official channels, or to something else? Investigators noted the calls and scheduled subpoenas where appropriate. All such steps were described in internal memos as leads, not conclusions. Administrative steps accelerated. The chief formally placed Brentwood on administrative leave at 11:29 the prior day. Rodriguez's court order meant that his suspension remained endorsed by the judiciary. The department's internal affairs unit issued a directive to preserve all related personnel files. Legal counsel prepared redaction-sensitive copies for external review. The mayor's office issued a brief statement acknowledging the incident, expressing confidence in the investigation, and promising transparency where possible. The public response was intense but uneven. Social feeds recycled the footage in hundreds of versions, some edited, some raw. That variance made the accuracy of the county's forensic copies all the more important. Within a week, an administrative hearing was scheduled to consider discipline and to recommend immediate reforms. It was not a criminal trial. It was the department's internal machinery convening in the shadow of federal scrutiny. In the hearing room, the exhibits were laid out in order. Counsel for the department and for the judge's interest walked members of the board through the same sequence viewers had seen: dashcam, bystander video, dispatch transcript, courthouse footage, personnel file, and phone records. Each exhibit was accompanied by a short legal explanation. The board asked practical questions. Why had dispatch cleared the plate before the officer handcuffed the driver? Had training covered the need to verify identity, particularly when a person produced government documentation? Were prior complaints against Brentwood adequately resolved? Had supervisors escalated training or remediation previously? Were systemic gaps apparent in the department's policy on stops involving suspected stolen vehicles? Lieutenant Foster testified about supervisory practices, how supervisors were expected to discourage unilateral escalation and to insist on verification when in doubt. She described prior instances in which she had coached officers on de-escalation and on deferring to dispatch updates. Foster also explained the pressure officers often feel in the field, a high-tempo environment in which rapid decisions have consequences and where seniority can, in practice, silence questions. Her testimony was sober and procedural. She did not demonize Brentwood. She emphasized instead institutional accountability and the necessity of systems that made correction easier. Officer Reynolds sat next to counsel and answered questions frankly. He described the culture among patrol partners, the difficulty of correcting a senior officer on the street. He said that the presence of independent recordings had made him realize the value of speaking up in the moment and in documentation. Reynolds's tone was contrite but constructive. He volunteered to take part in a future peer intervention training cohort the department was designing. The board, weighing testimony and exhibits, focused on immediate corrective steps. One member recommended termination. Another urged a remedial path, mandatory retraining combined with close supervision. The chief, mindful of both personnel law and public confidence, proposed a mixed approach. Recommend termination for cause if further review sustained substantial policy violations. Otherwise, recommend a substantial suspension with mandatory training and reassignment pending completion of a remedial plan. Because of the dashcam and the dispatch transcript, because the evidence had been preserved and authenticated, the board conceded it could not dismiss the matter out of hand. The combination of real-time video and corroborative dispatch records had elevated the situation beyond a typical he-said-she-said personnel dispute. Parallel to the administrative track, the U.S. Attorney's Office asked for certain documents and indicated that the federal review would examine whether there was sufficient basis to open a pattern or practice investigation, a civil oversight tool that could bring federal monitors into police departments if systemic constitutional violations were suspected. The U.S. Attorney emphasized the threshold for such inquiries, a supervening pattern shown by data and corroborated by institutional failures. The presence of multiple, similar complaints over time, coupled with the now documented incident, meant that the department would be subject to heightened scrutiny. For public perception, the interplay of timing and consequence mattered. The speed at which the dashcam image moved from street to courtroom to administrative file created a sense of immediacy that the press framed as instant justice. That phrasing risks misrepresenting complex legal processes. Internally, lawyers and investigators pushed back on hyperbole. Evidence can compel administrative action quickly, but criminal prosecutions and civil reform take time. The narrative of instantness was accurate insofar as it described immediate preservation and suspension. It was less applicable to long-term legal outcomes. Over the next month, depositions were taken and the evidentiary mosaic deepened. Investigators interviewed past complainants who had belatedly found their voice in light of the dashcam footage. Some described stops where the officer stayed on after radio confirmation. Others remembered being spoken to aggressively. Those statements were cataloged and compared to previous complaint dispositions. Where recordings had been absent in the past, the investigators noted the potential for underdetection of problematic conduct. At the same time, the department began to consider reform rather than only individual discipline. Chief Martinez convened a task force to examine policies on stops, use of force de-escalation, and the procedural requirement to verify dispatch information before detentions. Lieutenant Foster was named to co-lead a training redesign group, leveraging her field experience and the moral authority her decisive actions had earned that morning. The department asked external consultants specializing in police accountability to audit policy and training materials, and the City Council authorized a modest budget for new in-car camera systems and for peer intervention training modeled on contemporary best practices. Legal counsel and the U.S. Attorney's Office coordinated on the issue of federal oversight. The threshold for a formal pattern or practice suit is high. It requires demonstration of systemic constitutional violations across time. The U.S. Attorney's preliminary review did not announce immediate litigation, but it did recommend a deeper data-driven audit of stops, complaints, and discipline across the agency. For the department, the prospect of federal oversight, monitoring by an external party, was both daunting and catalytic. The human elements of the story evolved alongside the institutional ones. Reynolds enrolled in training and became an advocate for peer intervention. In internal presentations, he would later describe the psychological barrier to correcting a senior partner, and how the availability of objective data had helped him tell a truer account. He apologized to the judge for his hesitation. His willingness to cooperate and then to help lead change became part of the department's internal messaging about culture shift. Lieutenant Foster's role widened.
Her impartial, methodical supervision on the street had been an inflection point. Her promotion, when it came 6 months later, was grounded in both competence and a symbolic need for leadership that embodied accountability. Foster accepted the promotion to captain of professional standards with the explicit caveat that she would continue to advance peer intervention and de-escalation training across the department. Brentwood's personnel fate moved along parallel tracks. Administratively, he faced a disciplinary hearing. Criminally, the U.S. Attorney's review led to an investigative referral to a grand jury, in which potential charges for false arrest and deprivation of civil rights were considered. The documents show only the process: subpoenas, grand jury testimony, and a notation that an indictment was approved as to certain counts, pending formal arraignment. The record in this narrative does not assert guilt, only that an indictment was returned. Indictment is an accusation, not a conviction, and the legal system would proceed through its adversarial stages. Publicly, Chief Martinez stood before a press conference and announced a new set of reforms. The department would accelerate the rollout of body-worn cameras, mandate immediate verification protocols when dispatch information conflicted with field observations, and create a peer intervention requirement that expected officers to voice concerns in real time. Martinez emphasized that one incident had catalyzed a broader review and that leadership welcomed external oversight to restore public trust. He did not frame the measures as panaceas, but as necessary steps toward institutional accountability. 6 months after the stop, the department published statistics that suggested movement. Complaints alleging unnecessary escalation were down by a percentage that the chief's office described as promising initial progress. The department's reports showed increased compliance with documentation protocols and a higher rate of recorded stops due to body cameras being active. Independent auditors, engaged as part of a cooperative reform plan, reported that the department had adopted new training modules on reasonable suspicion, verbal de-escalation, and verification of identification.
They also recommended additional structural changes, regular audits of complaint dispositions, and a requirement that supervisors actively verify corrective action on repeat complaint officers. In that 6-month window, Lieutenant Foster became Captain Foster, overseeing the new Accountability Division. She redesigned training, emphasizing scenario-based instruction that used real dashcam footage in anonymized form to allow officers to critique decisions without retribution. The training stressed the constitutional standard of reasonable suspicion, a legal term meaning an officer must be able to point to specific facts that justify a brief detention. Trainees learned to articulate those facts swiftly and to rely on dispatch confirmation when available. The program also required officers to intervene if a colleague escalated improperly. Officer Reynolds, who had once stood by, participated as a training facilitator. He recounted what he had felt those minutes, described the institutional hesitancy to question a senior partner, and urged recruits to prioritize constitutional guardrails over unexamined loyalty. Reynolds's public transformation, an officer who admitted error and then advocated for reform, was presented as evidence that cultural change is possible when systems encourage rather than punish corrective action. Thomas Chen continued his role as a clerk and an evidentiary partner in the legal process. He collaborated with the judge's counsel in authenticating metadata and in demonstrating how citizen video plays a role in modern accountability. He did not seek credit, only clarity. In a closed training session months later, he described the responsibility citizen witnesses now bear, how their recordings can become critical evidence, and urged the public to document responsibly and preserve originals. Judge Washington returned to the bench after a short period away and resumed her calendar with the same composure she had shown on the street. She had requested that the court system develop a streamlined path for expediting preservation orders when public officials or high-consequence events were involved. The court adopted a modest administrative protocol. Motions could be filed with a single judge on expedited consideration for preservation and immediate notification to Internal Affairs and the U.S. Attorney where federal officials were affected. That administrative tweak was small but practical.
It reflected her belief that legal architecture should match the realities of instantaneous recording and public interest. In public remarks at a judicial symposium, Washington framed the incident not as a personal affront, but as a legal object lesson. She praised the procedural chain that had preserved evidence and had pushed for accountability. She spoke about dignity, how her own restraint was a tactical choice, and about the law, how it relies on record, not rhetoric.
Her words underscored a theme that had emerged in both internal and public fora. Evidence turns private acts into institutional obligations. The department's new training curriculum included an exercise built directly from the footage of the morning. The dashcam segment was used, with appropriate redactions and context, to teach recognition of error and the imperative to correct. Recruits watched and were asked to identify the precise moments where protocol could have reoriented outcomes. The exercise was blunt and pedagogical. It invited officers to see the human face behind a badge. Metrics in the epilogue were cautious and qualified. The early reductions in unlawful detainment complaints were reported alongside caveats. Short-term improvements do not guarantee long-term cultural change. External auditors cautioned that sustained reform required persistent supervision, transparent complaint resolution processes, and a willingness to act decisively when evidence shows deviation from policy. Brentwood's indictment, when it was announced, made headlines. The indictment charged acts connected to the detention. It also recited the timeline and referenced the preserved evidentiary exhibits that investigators had used. The filing set the stage for criminal adjudication, an adversarial process that would test the intersection of recorded evidence with state and federal standards. The narrative that had begun with a single mistaken detention had now matured into parallel processes: prosecutorial, administrative, and institutional reform. The department, in cooperation with city leadership and the U.S. Attorney, implemented a limited form of oversight. A monitor was appointed to review complaint dispositions for 6 months, to assess whether disciplinary recommendations matched established policy, and to report on the fidelity of remedial actions. The monitor's initial report was cautiously optimistic, noting procedural improvements and recommending sustained external review over the subsequent year. At a modest ceremony in the police academy, Judge Washington agreed to address a class of recruits. She did not lecture. She narrated the facts, showed a brief segment of the dashcam, with appropriate judicial permission, and asked the recruits to consider the human and legal stakes of each stop. Authority without accountability is dangerous, she said, but accountability without measured process is no less dangerous. The law is the bridge between power and rights. Her remarks were part admonition, part instruction, and part plea for a culture that makes correction a professional act rather than an admission of failure. Captain Foster, in her new role, stood before cadets with a similar message and with concrete steps: immediate verification protocols, mandatory peer intervention, and accessible avenues for officers to raise concerns without fear of reprisal. The training curriculum included institutional checks, supervisory confirmations after certain types of stops, random audits of body camera compliance, and a mechanism for civilians to submit footage directly to the department for preservation. Officer Reynolds returned to patrol under close supervision months later. His reassignment was gradual, and his performance was monitored for compliance with the new emphasis on documentation and intervention. He was public about his role in the wake of the local incident, and he worked with internal trainers to create a peer intervention module now used department-wide. Public trust, always fragile, shifted slowly. For some, the suspension and subsequent indictment were proof of accountability. For others, they were proof of a system that had been slow to change. The department published transparent updates on policy changes and complaint statistics. The City Council held hearings on the reforms. The U.S. Attorney's preliminary pattern review did not culminate in an immediate pattern or practice lawsuit, but it did result in a sustained monitoring arrangement and in commitments from the department to report progress quarterly to an external oversight panel.
A year out, improvements were measurable in some domains and aspirational in others. The rate of documented audio-backed stops had increased thanks to the accelerated body camera rollout. Complaint resolution times improved, and the number of complaints that lacked recorded corroboration decreased because more interactions were recorded. Training hours devoted to de-escalation rose significantly, but culture, being stubborn, required continual reinforcement. Judge Washington's final act in this arc was not one of vindictiveness, it was institutionalization. She authored a short administrative recommendation to the court system proposing that in any future incident involving members of the judiciary, prosecutors, or other public actors, expedited preservation procedures would be available. She also agreed to sit on a city advisory board convened to bridge court, law enforcement, and community perspectives on accountability. The photograph that would later appear in several news profiles captured a moment that summed the arc. Captain Diane Foster standing in front of a line of cadets, Officer Reynolds nearby, middle-aged and reflective, Judge Washington at the podium, neither triumphant nor embattled. The image embodied a complicated lesson. Visible evidence forces institutions to respond, but the work of repair is slow and requires leadership willing to translate immediate accountability into structural change. The narrative closed not with a single dramatic verdict, but with the cumulative movement of practices, preservation orders, suspension, federal review, training overhaul, and ongoing monitoring. The officer's mistake had been shocking precisely because the record made it incontrovertible.
That record had not only produced immediate administrative consequence, but had triggered a cascade of reforms aimed at preventing repetition. In the last scene, months after the handcuffs clicked and the dashcam light had blinked, a new set of recruits filed into the academy. They were younger than the weathered supervisors who taught them. They watched a montage, a dashcam approaching a vehicle, a calm hand presenting an ID, a pause, the removal of restraints at the command of a lieutenant who knew procedure. The montage ended with a caption about preservation and a single line: "The law matters when the record exists to prove it." Outside the classroom, Judge Washington returned to the bench. Her calendar resumed its steady rhythm. She read briefs, heard arguments, and signed orders. The morning of the stop remained a defining day in her docket of public service, not because it elevated her personally, but because it revealed how, when documentation meets diligence, a single mistake can become the fulcrum for broader justice. The dashcam did not erase error. It required an answer. The institution, prompted by evidence and principled intermediaries, provided one. If you believe accountability matters, if you want stories where recorded truth meets institutional consequence, subscribe and follow the thread, because the work of reform is ongoing, and the evidence we preserve today shapes the justice of tomorrow.